the general proposition that modern guidelines can just provide a basis for giving an above guideline sentence does run afoul of the ex post facto clause, where the district court is not pointing to some specific aggravating factor. For example,
would we have to overrule Coe to find for you where we said it's okay to look to guideline amendments to justify a variance?
No, not at all. In fact, I think the court should rely on Coe. It's okay to look at amendments. That's perfectly okay. You can look at an amendment. But that's not what happened here. So for instance, if the applicable guidelines didn't take into account, this is not the case, but for instance, the age of the victim, and modern guidelines do take account the age of the victim, then it would be appropriate under Coe to say, I'm going to rely on the age of the victim as a basis for going above the guidelines. But here what we have is sort of this general idea that modern guidelines are more harsh. We care more about child pornography now, and modern guidelines are more serious or are punish the conduct more severely. This is just an end run around the ex post facto prohibition. So if the court could have gotten there, but there needed to be some precise basis, and neither the court, the government, or probation, really anyone, has identified a specific aggravating factor that was not addressed in the applicable guidelines. And that is the reason that this is just a Pew violation rather than a proper basis for going above the guidelines. I have about 1 minute left. I want to briefly touch on the statute of limitations issue, which I think the court is probably well versed in. But the point I want to make is that the government seems to think that so long as retroactive application doesn't violate the ex post facto clause, it's good, no problem.
And you're not arguing otherwise, correct?
I'm not arguing otherwise. What I am saying is that we still have to start with looking at what Congress intended. And that first starts with the language that's used by Congress in the statute itself, which is the best indicator of Congress's intent. And then you can also look at the legislative history. And our position is not only did the statute use language like would and shall, which we know is future type of language, but it contains no language about retroactivity. And in fact, there was language, a prior version of the bill did include language of retroactivity that was excised in the final bill. So I think we could see that Congress intended this to apply prospectively. I see that my time is up. I can address any further arguments on rebuttal. Thank you.
Thank you. Mr. Williamson.
Good morning. May it please the court, Brian Williamson on behalf of the United States. The district court did not procedurally err and did not abuse its discretion with regards to the substantive reasonableness of defendant's 240-month above guidelines sentence. The district court started with defendant's proposed guidelines range and then went above those guidelines range upon a thorough explanation of the 3553A factors. As such, the primary basis for the above guideline sentence was the court's finding that the offense conduct was horrible, horrific, and deserving of very, very serious consequences for Mr. Kelly. I think the court has already picked up on that. Defense counsel loses the forest for the trees a little bit in arguing that the above guideline sentence was based solely and exclusively on the obstructive conduct. And
is it your view, Mr. Williamson, that the court did rely on the obstruction of justice conduct in imposing sentence?
Your Honor, so I think it's important to clarify that the starting point was adopting defendant's guidelines range.
But as a basis to vary.
I think it was a data point in justifying the above guideline sentence. It was not, neither were imposed specifically as a mechanical basis to vary above.
And can you distinguish for me between what you mean by a data point and a basis to vary?
Right, Your Honor.
Did the court consider it? It's hard to tell from the court's comment that it could consider. And I'm not sure there's any specific finding by a preponderance of the evidence as to why the obstruction of justice conduct occurred, or that the government did prove it by a preponderance of the evidence.
Yes, Your Honor. So, the sentencing court found by a preponderance of evidence that obstructive conduct occurred. Now, whether that comprised a specific part of the above guideline sentence or whether that was a further justification aligned with the seriousness of the offense conduct, the sentencing transcript does leave that a little bit ambiguous. But it's clear that on the offense conduct alone, the 3553A factors alone, and the seriousness of the conduct, the court could have arrived at the 240-month above guideline sentence by itself. So
just to pin this down with clarity, your position is that Judge Lynam-Weber made the findings necessary to consider the obstructive conduct.
yes, Your Honor.
Okay.
So as to the obstructive conduct, per this court's precedent, it is not in dispute that a district court may consider acquitted conduct as long as it is proven by a preponderance of the evidence. And that's exactly what the district court did here. Moreover, it's clear what the sentencing court was referring to. He noted a Keystone Cop kind of operation in which these tapes spread throughout the country. And Kelly's minions spent hundreds of thousands of dollars in effort trying to get them back. This is not just about the receipt of the tapes. This is about a broader sense of obstructive conduct. If you read the sentencing transcript in whole, it is quite clear that, as the government argued, there was a broader set of obstructive conduct that was in the court's mind when he made those comments. That included conversations that Kelly, the defendant, and his associates had with Jane's parents during the course of the investigation. The result of those comments, including Jane's family's non-participation in the grand jury and subsequent 2008 state trial, payments made to Jane's father during that time period, and others. The burden on the sentencing court to justify an above guideline sentence is not high, and it was more than met here by the court's consideration of the 3553A factors. Moreover, it's also not in dispute that there was no ex post facto violation in the court's reference to the evolution of the sentencing guidelines on sex offenses. Defendant concedes as much in his papers. Your Honor, you mentioned the Coe case, and that's exactly on point here. It actually encourages reference to amendments to the guidelines without reading into the limitations that defense reads into it, that those should be used by later sentencing courts in considering whether their sentences meet what Congress was intending. So at end, the sentencing court based its 240-month above guideline sentence primarily on defendant's horrific offense conduct, not in particular on either his obstruction of justice or the evolution of the guidelines. The sentence was thus procedurally and substantively sound. Turning to the statute of limitations question, defendant's indictment for sexual exploitation and inducement of children was timely brought. The statute of limitations period as to defendant's victims never expired, and at the time of the offense conduct, prosecutions were viable until the victims turned 25. But before Jane, Nia, or Pauline reached the age of 25, Congress in 2003 expanded the statute of limitations period to the life of the child. This was unambiguous. Section 3283 states that no statute of limitations that would otherwise preclude prosecution for an offense involving sexual exploitation of a child shall preclude such prosecution during the life of the child. This is a universal approach to changing the statute of limitations. It's forward-leaning and it's backward-leaning. There is and can be no ex post facto violation when an otherwise viable statute of limitations period, such as we have here, is expanded. Multiple courts of appeal agree on that front. And while this court has yet to have occasion to review that specific question with regards to that specific statute, 18 U.S.C. 3283, it is nonetheless agreed with the principle that no constitutional violation occurs in these circumstances. That's the United States v. Gibson case, relying on Supreme Court precedent in Stodner. The application of 18 U.S.C. 3283 should thus not be considered impermissibly retroactive. It is not reviving a previously moribund limitations period. Instead, it is explicitly precluding the application of prior limitations periods that were anything less than for the life of the child. The indictment in this case—
Are you saying that the land graph analysis doesn't matter given Gibson?
I wouldn't
Because
set
it seems
aside—
like it's a separate issue. The Gibson is the ex post facto argument, and defendant has conceded that's not what he's pursuing on appeal. Instead, he's arguing the statutory construction, that if you look at Congress's intent and look at the framework under Landgraf, that Congress's intent was not to make this retroactive, which is a separate issue.
Your Honor, I think the language of the statute speaks unambiguously, and we don't even have to get to what the underlying intent of Congress was. It's hard to read 3283 in a manner that doesn't apply both backwards and forwards. If we do apply Landgraf, it satisfies both the first step and the second step.
Defendants spent a lot of time in the brief focusing on the 2C case and the statements that statute of limitations should be liberally interpreted in favor of repose in criminal cases in particular. Can you respond to that argument, please?
Yes, Your Honor, absolutely. So the 2C case and its progeny, that's a fine statement of what 2C stands for, but there's always a carve out for when Congress explicitly provides for otherwise. And it's the government's position that that's exactly what 18 U.S.C. 3283 does.
What if we get to step 2 of Landgraf? How would 2C impact that analysis?
So in a sense, defense is asking for a kind of an exception that doesn't exist with that. Reading repose into the second step of 2C, in defense's brief, they set out that this creates, there's a broader set of rights and obligations in that than are provided specifically in the second step of Landgraf. I wouldn't say we need to reach the second step of Landgraf because step 1 is satisfied given the unambiguous nature of the statute. And
But if we do,
as to step 2, if there is no retroactivity problem, we're not even in step 2 of Landgraf. And I'm not sure they've pointed to a case that says that the repose considerations in 2C supersede the satisfaction of steps 1 and 2 at Landgraf. So if the court doesn't have any further questions. Thank you.
Thank you.
Ms. Bonjean.
Thank you, members. Picking up where my colleague left off, our position, of course, is that it is not okay to just jump to the ex post facto problem. And we disagree on the language of the statute and what it suggests. We have express language from the bill version that demonstrates a desire to include a retroactivity provision that was then removed. Now, retroactivity doesn't mean an ex post facto violation. And retroactivity could be an ex post facto violation, but it doesn't mean an ex post facto violation. And so we are in this category where we acknowledge that the government, that this was not, again, a situation where the statute of limitations has expired, but it was still retroactive. And there are still considerations that this court considered, and that the United States Supreme Court has said the starting place. And in Landgraf, the court says the default position is prospectivity. So we shouldn't start with the retroactivity unless otherwise. 2C says criminal statutes should be interpreted in favor of repose. So those general principles, those canons, need to be the starting point. And I think lower courts, to some degree, have gone wayward from that. I think the U.S. Supreme Court might get us back on track with that. And I know some.
But if the language is clear at step 1, that doesn't come into play.
Well, the language,
I understand you don't think it's clear.
Well, I think it's clear in the other direction, but
if it is not clear in the direction you want it to be, then we don't get into the 2C land.
Well, our position is that the legislative history, we also agree that you don't need to get to step 2. So we're in agreement on that. But, and obviously we would acknowledge that some of these circuits have already sided with the government's position on this, the issues in front of the Second Circuit presently. So
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But perhaps there will be a split at some point. But our position is that the U.S. Supreme Court would see this differently in light of those general principles, and that we need to start there. And I think the court is well equipped with the information that we've provided and the government's provided to make that decision. I want to get back to this obstructive conduct very quickly. I'm still unclear. I think the government is unclear. Everyone is unclear on how the court reached the above guidelines sentence. And I don't think it's sufficient to just say, well, he spent a lot of time talking or speaking about the 3553 factors, and therefore it's all justified. I think that's dangerous, and I think the court needed to be a little more precise with its factual basis. And notably, the government is focusing this court more on a different set of obstructive conduct for which Mr. Kelly was also acquitted that the district court didn't even mention. The government talks about the intimidating behavior, the hush money towards Jane Doe and her family. And in our reply brief, we honed in and demonstrated for the court that is not what the evidence showed. Jane Doe said nothing of the sort. She said there was no hush money. The mother unequivocally said there was no hush money to testify falsely in front of the grand jury. Nothing of the sort happened. They had their own reasons for wanting to not cooperate with the investigation, and it wasn't as a result of Mr. Kelly's conduct. Now, the government, interestingly, is focusing that court in that direction, but the district court didn't mention it at all. So the district court didn't rely. At no point did the district court say, I'm going to give him an above guidelines range because he engaged in obstructive conduct as it relates to his interactions with Jane Doe 1 or her family. He was more focused on really what was the receipt counts about this wild goose chase. And I want to end on the point that the evidence showed that those tapes that were the subject of the wild goose chase, which were pled and charged in the indictment, did not contain child pornography, contained old-fashioned pornography, if you will. It did not contain child pornography, and the government didn't prove it, which is why the jury came back as it did. And there is really no avenue for the court to find under this lower standard that it did. If it did, then it's unclear why the jury would ever have acquitted any of them on the conspiracy count. So our position is the district court judge got that wrong factually, if he relied on it at all, and that the sentencing justification was too nebulous and that we needed a more precise basis, because how else can Mr. Kelly defend that if he doesn't have a specific articulated basis? With that, I thank your honors.
Thank you. Our thanks to all counsel. The case is taken under advisement. Our next case this morning is United States against Dylan Ostrom. All right. Good morning, Mr. Tice.
Good morning. May it please the court. My name is Bill Tice, and I represent Dylan Ostrom. There's one key fact.
How y'all think she did, you guys? The judge was kind of, I don't know. But Jennifer did, I feel like she did a good job. We just don't understand. It was the same way with Bill. But you have to remember, you guys, she is only working on, trying to get Robert, a lesser sentence as far as that. She has to speak on case law, you guys, and we don't understand case law like that. Like, if we did case law, if we read on the case law, and we find out, well, yes, they only have 15 minutes. J.E., they only have 15 minutes to argue. So that's not a lot. You have to remember that. She try to get the key points out, the most important key points out. Jennifer Bonjean is a great appeal attorney. Go back and look at her background. And so she's basically pointing out the mistakes from the judge. Okay. You know, yeah. So like when the attorneys argue, they bring up case laws, and you know, that's how it is. And then we have, and you know, she's a female judge, and I thought it would have been like three. I wish it would have been three. I wish it would have been three. And I think it's just three in the higher courts. So this is more of a, you know, appeal on a lower level. And basically she also said, you know, she was like, okay, you know, you're taking a risk, you know, you understand, do your client understand if this goes back to trial, you know, it might be even worse. And so Jennifer Bonjean was like, okay, wait a minute, you know, if we go back and this judge is doing this out of retaliation, that's not right, you know. And so basically, you know, just like any other attorney, they try to take lemons and make lemonade. And she's working really hard on this. And you know, the CP is really hard to fight. Y'all have to understand, CP is really hard to fight. In my opinion, Jennifer Bonjean did a excellent job. And you know, and I'm gonna keep that, you know, in my head, because she has, if you have to go back and look at this sister's background, you have to go back and look at her background. I wish they had more time. I think they give them more time in the higher appellate court, but you know, usually they have 3 to 5 judges, and then the judges go back and ask questions. It's like you have a mixture of men's and women's, and that's what I like about it. I don't like the one judge, you know, deal. I don't like that, the one judge. I like to have them, and I think that all you know, appeal courts should have a mixture of male and female. Because she came out, you know, she's like, oh my God, she said, this is serious, you know. It started, but you can go back. I'm gonna get the link for you guys so you can go back and look at it at the beginning. But it had just started when I put it on there. But she was speaking as fast as she could. She was putting out as much information as she could. You know, she did the 10 minutes, and then she kept 5 minutes to argue against the state. So you have to understand, I feel like she did great for 15 minutes. And just think about it. When I come on here and I plan on, you know, having a content to talk about something, and I'm like, okay, I'm gonna go like 30 minutes to an hour, and I go past that because it's so much to talk about. There's so much stuff that went wrong in the lives and the you know, things in Robert's situation. They don't give more time, baby. They didn't have but 15 minutes, sweetheart. 15 minutes and 15 minutes only. But the other with the higher courts, like when you have 5, you have the 5 judges asking questions. You might have 3 ask a question, maybe 1, but they're gonna ask you questions, so they give you more time to break it down. You know, but this one judge, and you know, and she's like, okay, I understand that, but you know, yada yada. She did not stutter. Jennifer Bonjean didn't have to think. She didn't waste a breath. she, whenever the judge, asked her something, she was right on it. Question: did this was the okay? I'm sorry, I need to put Chicago on there. I apologize. Let me put Chicago on here for Chicago. Thank you, sweetie. I apologize for that. Okay. Yes, it was the Chicago. I apologize. Thank you. Um, that was why he appealing. That is the point of appeals, right? Um, see, you got to understand the. That's why, like, I've been actually watching court, and I wanna watch YSL. I'm gonna go back and watch YSL because I'm gonna tell y'all something. I'm learning a lot. Like, these people go by case laws. You hear me? And then they're like, when they do an objection, why you want to object? And then these people quote a case law, and the judge will probably do a sidebar, and he'll look it up, and things like that, or he'll, sustain or object, and things like that. And I find it really interesting. And I wish that we had this when I was younger, because hell, I would have went into law. Like, my family wanted me to go in something, a medical field, and I don't do well with my own sickness. Get your snack and make sure you take your meds. I got my snacks. Matter of fact, I'm gonna go on here and look. I love watch YSL. That damn judge off the chain. Let me hold up, y'all. Just give me a minute. Let me find it. I'm gonna just look at a little bit of it with y'all, so I can talk my mess. I'll be over there talking mess. Yeah, that was JE. I feel that I know she should win New York. Damn, they already into oh good lord. Damn, I want to blow it up. Wait a minute, let me go find another one. I don't want to. Damn it. Let me find another one, y'all. Try not to go YSL. See, they already looking through paperwork. The state is sneaky as hell, y'all. They be trying to sneak damn discovery in there at the last minute. But that damn Mr. Steele and that black guy, I really like him. I like him. He ain't playing. Okay. Yeah, we can do this. Give me a minute, you guys. Yeah, I catched it all, but I had to come downstairs and put it on my computer, so I want to share with you guys. But we'll go back and look at it if you like. I can redo it because it didn't take long. It was very quick, but we can go back over it so we can see what's actually happening. But she did good. I don't. She didn't waste a breath. Because she did a great job. Sister did a great job. Shout out to her. See, they waste a lot of time.
Handed you in form of state's exhibits 145 Charlie to 149 Charlie. Three of these, 145 Charlie, 146 Charlie,
Right, Chrissy?
149 Charlie, are the known reference samples that are listed in my report as items 6, 7, and 8. I recognize them by the DOFS case number on the sticker, as well as, hard to see, but across the evidence tape, as I resealed the evidence after testing, my initials, GAP, just like the store, and the date,
Yeah, Chrissy, yeah.
along with the
We should
evidence
talk
sticker
about
that
it.
includes the known reference sample names. These two, which are 147 Charlie and 148 Charlie, are the two exhibits that are listed at the top of the report. So DOFS numbers 11 and 12, which are swabs of stains from items 4A and 5A. Recognize these by my handwriting listing out the DOFS case number, a description written on the package, date, my initials, as well as for sealing purposes, my initials across the tape, and none of these look to have been opened since I last closed them.
Right, at this time, the state now moves based on the testimony to admit states exhibits 145.
Do y'all notice with the YSL trial,
Any objection to state?
each day the prosecutors change up?
Yes, Your Honor.
They will have a white man and the two black girls. They got the two black men. And I'm looking at how they playing teamwork. It's like whoever they have on the witness stand.
Subject to your agreement, okay? All right. And, so stage
and
140.
What's up, Queen Chris? I haven't seen you in a while. Frankie, Johnny, 6'7". Thank you, Mod. Thank you, Miss J. I know it's morning time and the people working as well. But I wanted y'all to like start whenever y'all get time, start looking at.
So at this point, for
Break
clarity,
everything. Thank you,
I
baby.
apologize to ask for clarity. To open this, I do not know what is inside of this. For evidence integrity, I don't have a clean surface. I'm not wearing proper PPE. So I will open, just want to open it with that understanding.
Yes, please.
Yes, sir.
I don't, y'all tell me this. Do y'all feel like they should, now this is in evidence. The person has been charged. The person has already,
There's one more envelope inside.
has already, been punished for the crime. Why y'all taking all these crimes that these people did and trying to make a RICO and so they can redo the punishment? That seems like double jeopardy to me. I'm just not getting it.
Would you like me to remove the evidence?
Maybe one day I'll get it. I want to go to school for law because I want to understand more, you guys. I
They're
swear.
cotton swabs, similar to the Q-tips we discussed earlier. They're wooden sticked with a cotton.
Okay, so now they got the
and these are the buckle samples
experts.
Identified as Walter Murphy.
I'm gonna mute it so we can talk. But how y'all feel about this? Just like with Robert, and that's what Jennifer Bonjean was speaking on. I want to go back. I want to go back on that too, so we can talk about it some more. The appeal, Jennifer Bonjean. For them to go back and say, well, it's clear that they are abusing the RICO system. They are really doing that. And just look at it. They really it's not making any sense. And then with Robert, they charged him for a RICO, and I'm comparing all these other RICOs and other extra people being in there. But they did say one or more. But at the same time, all the RICOs that I've been looking at, I've been seeing, 2, 3, 4, 5, 6, 7. And YSL, they got so many judges, I mean, so many counselors sitting with them and defendants and stuff. And I'm not understanding this. Robert sat alone. They tried, along with damn people, on these YouTube streets, tried to add extra people and then make the outside people feel like, oh yeah, he did this. You got, on the newspaper and the news, you got what's his name? Christy. I just had my treatment, so I'm a little blank, so y'all forgive me. But you have Dabowski, right? They put Dabowski in this. They put Dunn in this. Then they use Michael Williams. Then they use Richard Arline and Don Russell. And they put it all out there to the public, the media, to spin a narrative that Robert is got all these people out here doing things to cause mayhem. And I noticed this. Every time something goes on with Robert case, or a trial or a hearing or whatever the case may be, bullshit come up, right? Look what happened with Sylvia. And this is, and of course they're gonna be like, oh, this is a woman. Like, I'm listening to other bloggers that has nothing to do with fighting for Robert. Oh yeah, this woman here, she taking up for R. Kelly the P, and just pay attention to what the media did. They talking about us and talking about the fans and talking about, oh, they sitting out here, they doing this and they messing with the accusers. No, we are pointing out the facts. The media lied. They spent a narrative. Those very people that they had to pick. And you can use Don Russell's when they was picking his damn jurors, what the hell they said. You had 30 out of 80 said anybody that is with Robert Sylvester Kelly is a monster. Come on, y'all. You think this man had a fair trial? And I love what Jennifer Bonjean said about the mother. The mother did not say that. She was basically saying, she was trying to say, hey, no, he did nothing like that. And Roshonda Landfair lied, and I remember me showing y'all all these damn videos of her overseas. He's overseas now. She's overseas with her group doing shows. And this was when she was older. Queen, he said. So you know what I'm saying? So I'm looking at all these different cases. I'm looking at how the government is working. And so I listened to the judge actually tell the defense team, wait a minute. This is their they brought this indictment in, and this is their job. This is what they supposed to do. They supposed to prove their guilt, but still it's like, and we're supposed to work for our clients and prove they're innocent. So I said, damn right. Because like I told y'all, now everybody like, oh no, it's for the prosecutors to prove that they're guilty. It's not on the burden is not on the defense team. Yes, the hell it is. They got to go in with sharp claws and fight for their clients because these prosecutors are dirty as hell. You got 400 fucking witnesses, and then you want to slip in stuff, and then you tell the judge, oh, well, they said they lost it, and so we got to go. They moved, and we have to go and find it. But once we find it, we'll bring it. And then the judge himself have to understand that the defense team, they got to get their investigators, they got to get in contact with these people, they got to get their deposition going so they can ask those people questions and get all this stuff done. You had Mr. Steele had to tell the judge to make one of the witnesses speak to them. And the judge said yes. And you tell him I said to be here in the morning so he can speak to Mr. Steele and the others. And for them to have to sit outside and talk to this man, and they didn't have at least 2 days to get stuff together, that's messed up. The judge is supposed to be impartial. That's what I'm telling you, Mr. J. It is sad to me to watch how they are doing. Was any of those 3 tapes Avnon mentioned presented? No, that's what I'm saying. And then remember, with New York, they said all these devices and stuff like that. But y'all remember when I said, as a counselor, you have to be animated, baby. You have to put on a show. You have to be animated. Did you see what those prosecutors did when they knew the media was out there? Because a lot of these jurors try to pretend like they ain't watching stuff outside of what the judge saying. I guarantee you they probably got some friend or a family member got, looking the stuff up and they talking about it. And was it fair for Robert? Because almost everybody saw the surviving lives. But the 3 women had that court with all that damn paper, and did y'all see all that paper being presented? The ones that went to cover the trial? Hell no. Because looking at the transcripts, I'm like, what the goddamn devices is? What all these tapes is? What Larry said the same thing. Oh, y'all just don't know. It's a bunch of tapes of these women, these girls, and then you got the damn daddy, Papa manager, Angelo, telling everybody, getting on the media, getting on YouTube and everywhere else saying, oh, they got so much discovery, all these tapes. Only thing that they played with 2. And that was consensual sex, threesomes. A lot of people do that. Like I said, what floats these people boat in their sexual lives. And then Robert's a monster. Like they didn't have anything, Queen Chrissy, nothing. I'm like, I compare everybody. I listened to everybody, and then I was on, read the transcripts, and then when you do your research and what these people didn't do anything. These people didn't do their research. So only thing they go on is he was just found guilty. Okay, y'all know how many people last year was released that was in jail for 10 years and more because of they guilty. They look guilty. And the government didn't have evidence. Oh, but they look guilty. Oh, the government said that they did it, so they did it. Instead of people being free thinkers sitting there, I want free thinkers to be the 12 people Yeah, old fashioned porn. That was it. But I want to go back over it though. I'm gonna watch YSL later, but I want to go back over what Jennifer Bonjean was saying. And remember, you guys, attorneys speak a different language from us. We have to understand. I did a business law. I still have my business law book, and I need to go back and read that as well. But it's thick. So this lady, Jennifer Bonjean, she practices different laws, and that's a lot. And then you got to go through, the reading and stuff like that. And I pray that her law firm, grows big. I pray that it harvests. I pray that it harvests. But I just and people can say what they want. Y'all know I don't care what they say about me. Oh, she's going for a predator. No, baby. I know this from that. I experienced a lot of this shit that went on in Robert Sylvester Kelly's case. I experienced the women lying. I lied about my age. What in before us, they have taken out the back door because they weren't in the courtroom. Yes. Let me get the link for you. Just give me a second. But I want to go back and listen to it again because I like to listen a second time because I'm the type of person. Sometimes I try to listen, but when I get distracted, I'm that type of person. So I want to go back and listen to it again to that's what I want to do. Just give me a little bit. Thank you, Maz. I appreciate y'all as always for holding it down. Y'all are so great. Y'all so great. Okay. Let me go back. Matter of fact, they were the first ones. Okay, it said live stream is offline. Okay.
Testing, testing.
Okay. You're testing the mic. Give me time, you guys. I'm trying to fast forward.
Have acquitted any of them on the to find that the United
There is obstruction of justice. Defendants propose
If he wins,
position
States against Kelly. Ms. Bonjean.
Can y'all hear it? Oh, thank you, sweetie.
Thank you and good morning, Your Honors. May it please the court, my name is Jennifer Bonjean and I represent Robert Kelly. I am going to work backwards this morning and start by addressing the sentencing issue, but happy to field questions about any of the issues before the court. Mr. Kelly was indicted in a 13-count indictment. He was convicted of 6 counts. He was acquitted of 7 of those counts, including obstruction of justice based on a 2008 state court prosecution, conspiracy to receive child pornography, and then the receipt counts. Mr. Kelly was sentenced to a 240-month sentence, which was the statutory maximum, and a sentence significantly above the guideline range. And the district court judge properly calculated the guidelines, but then gave just essentially a polite nod to them and decided, I think 20 years is the right sentence. And the district court's justification for the above guidelines range lacked sufficient factual basis. That is our position. Generally speaking, he relied on acquitted conduct, and he relied on the guidelines today would punish this more severely. Therefore, we should give him an above guidelines range. Now, I want to first start with the acquitted conduct. If you look at the district court's comments, he both imprecisely and inaccurately stated that the evidence presented at Kelly's trial essentially showed that he engaged in some type of obstructive behavior.
Ms. Bonjean, do we know, though, that the district court actually relied on that? Because the district court said, I could find by a preponderance that he obstructed justice.
And
There
yes,
was no specific finding that he did.
Yes, and that's an excellent point, Your Honor. Our position is the judge was imprecise. He vaguely referenced, I could do this. It could be based on
But
this.
you want us to infer from that he actually did.
Well,
And what's the basis to do that given the judge's specific comments?
Well, I think what I would like the court to do is first find that his comments were too vague and ambiguous for us to find that what he relied on. And I think in our briefs, we said it was both procedurally improper. And then we argued that even if you accept the government's position that there was this basis, the judge did make this finding. And the comments were sort of a little bit of a stream of consciousness, if you will. And he said, I could do it. So our position, as our briefs, I think, set forth, is that it wasn't precise enough. He didn't identify the factual basis. But even if we looked at those factors, they would not provide a basis for an above guidelines range.
The district court sentencing seemed very grounded in the 3553 factors and his concern for the seriousness of this offense and your client's history and characteristics, which is exactly what courts must do, is look at the 3553 factors. How do you get around that?
Well, I think you still have to look at the guidelines range as a starting point. And I would remind the court that probation found that there was no basis to sentence him above the guidelines. And
But that's not determinative. The
Of course.
court has to look at 3553, which again, the court spent quite a bit of time on those factors, in particular, the seriousness of the offense, the need for deterrence here, protecting the public.
And those were all appropriate factors to look at. But when a court decides to go 72 months above a guidelines range, it still should identify factually specific aggravating factors that would justify it. Not simply say there was this acquitted conduct that I could find. And again, our position is the government did not prove the acquitted conduct by a preponderance of the evidence. We know that because the jury acquitted him of the conspiracy to receive child pornography. So this wild goose chase that the judge referenced as sort of a basis for this above guidelines range is not borne out at all. In fact, the jury affirmatively rejected the government's narrative.
Different burden of proof.
It's not logical. We sometimes see cases where maybe the government just didn't meet its burden, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. It's the same child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography. And then they acquitted him of the conspiracy.
Ms. Bonjean, if we agree with you and send this back for resentencing, does your client realize he could end up worse off? Because the court did go above the guidelines, but very significantly, only 1 year is consecutive to the sentence that your client received in New York. So theoretically, if it's remanded for resentencing because of an error and the court gives a guideline sentence, which is what you seem to be arguing the court should have given, that entire guideline sentence could be consecutive or half of it or more than a year, which would put your client in a worse position. So does your client realize that?
Yes, Judge. I do think that if the net result was a more significant.
Okay, basically what she is saying, y'all, Robert was acquitted of 7 other charges. And so basically what she was trying to tell Jennifer Bonjean, okay, so if we go back, like if we agree with you, and then so I don't know if basically look like she trying to do a retrial or something. I don't know. I got to go back and read the paperwork. But she said if we agree with you and then we do a retrial and he go back to court, what if they give him all the charges? Why if they find him? Yeah, it's live from this is the argument. Miss Moore, it happened this morning. It just over with. It was real quick, but we going back over it. I like to listen to it, more than one time, so we can, get the understanding. So right now we just doing a recap of everything. So this is Jennifer Bonjean arguing with the Magistrate of Appeal, and so this is what she was just trying to, say to Jennifer Bonjean. So if somebody say, okay, well, it first started off with me as this judge is being so rude, but then I have to understand. That's why I have to listen more than one time. So I have to understand. She's saying that if I grant a resentencing, he will get more time. See, that's what I'm saying. So basically, this is what she's saying. So now let's finish listening to the answer Bonjean has for the question.
Sentence, it would be retaliatory for exercising his right to appeal. So I don't think the judge could, and I frankly don't think the judge, would do that.
Certainly could. If it's sent back for resentencing, the judge could start over and look at everything. So to say it would be retaliatory, there's no grounds for that or no case law that would support giving a higher sentence or a sentence that would have a more significant consequence.
Well, I think the second point is a more, I think, a valid point to some degree, but I do think there's plenty of case law that says you can't punish someone for exercising their right to an appeal, right? So if the judge were to give a net greater sentence, our position would be that was retributive.
I just want to make sure your client understands that if he wins on this particular point, he has risks that he might get a higher consecutive sentence.
Yes, Judge. And frankly, to be frank, kind of all depends on what happens in the Eastern District, because that's
on appeal.
That's his life sentence right there. Essentially, it's a 30-year sentence. So not to say this doesn't matter, but if that sentence sticks, he probably will die in prison. And that is the reality. So we have had these conversations if the court, is asking that, and we understand that. We had those conversations before we even went to trial, frankly, and he understands all of that. I would argue, and just moving on to, again, the general proposition that an ex post that the general proposition that modern guidelines can just provide a basis for giving an above guideline sentence does run afoul of the ex post facto clause, where the district court is not pointing to some specific aggravating factor. For example,
Would we have to overrule Coe to find for you where we said it's okay to look to guideline amendments to justify a variance?
no, not at all. In fact, I think the court should rely on Coe. It's okay to look at amendments. That's perfectly okay. You can look at an amendment. But that's not what happened here. So for instance, if the applicable guidelines didn't take into account, this is not the case, but for instance, the age of the victim, and modern guidelines do take account the age of the victim, then it would be appropriate under Coe to say, I'm going to rely on the age of the victim as a basis for going above the guidelines. But here what we have is sort of this general idea that modern guidelines are more harsh. We care more about child pornography now, and modern guidelines are more serious or are punish the conduct more severely. This is just an end run around the ex post facto prohibition. So if the court could have gotten there, but there needed to be some precise basis, and neither the court, the government, or probation, really anyone, has identified a specific aggravating factor that was not addressed in the applicable guidelines. And that is the reason that this is just a Pew violation rather than a proper basis for going above the guidelines. I have about 1 minute left. I want to briefly touch on the statute of limitations issue, which I think the court is probably well versed in. But the point I want to make is that the government seems to think that so long as retroactive application doesn't violate the ex post facto clause, it's good, no problem.
And you're not arguing otherwise, correct?
I'm not arguing otherwise. What I am saying is that we still have to start with looking at what Congress intended. And that first starts with the language that's used by Congress in the statute itself, which is the best indicator of Congress's intent. And then you can also look at the legislative history. And our position is not only did the statute use language like would and shall, which we know is future type of language, but it contains no language about retroactivity. And in fact, there was language, a prior version of the bill did include language of retroactivity that was excised in the final bill. So I think we could see that Congress intended this to apply prospectively. I see that my time is up. I can address any further arguments on rebuttal. Thank you.
Thank you.
So you see, she didn't really, they had a clock in front of them. So, but they didn't show them like they showed like Bill Cosby with the judges talking to them, but it was just more of vocal. And so that was her argument, but we're going to go in and listen to the prosecutor's argument. But it's just like basically what the judge is saying, okay, he got acquitted of 7. Now, if you go back, he can look at everything. So after that, after she argued about that, she started talking about the statute of limitations. And y'all remember I was saying these very words, small words, should, if, I, me, could, would. These little small words are important. That's why I said people be like paying attention to the big words. Pay attention to the small ones too. They have meaning. Just like with Demetrius Smith, when he spoke and he said, I did, me, all that. I came up with the idea, He didn't say we. He didn't say Robert, advised me to do this. Robert, told me to do this. Robert made me to do this. Everything that this man, Demetrius Smith, did, told the people, I did this. I did this. And then you have to look at if you pay attention to you have to pay attention like to the trial YSL. If you notice, the defense team, when they speak to people that got immunity, they make sure they bring it up. So are you up here saying what you're saying because the government, gave you immunity? See, the government don't want you to bring that up. But if the door is open to bring it up, they're allowed to bring it up. And when Jennifer Bonjean spoke on the New York trial, she was speaking on the counselors wasn't effective. It's just like they didn't do anything. They didn't try to do anything. They went in, took his money. It was just a bunch of mess going on, arguing back and forth with each other, not sharing discover with each other and things like that. And I think that with Jennifer Bonjean, when she's speaking on New York, she feels so good about New York. Um, she just wanted to knock Chicago out and focus on the New York trial. So it's a lot, with this. So it's just like getting the understanding, because like we listen to it. It sounds like alien language to us when these counselors speak, but they're speaking like on these case laws. So like I try to write down the case law. Who said I didn't say anything about not wanting him free? Who said it? Unless it's going something going on in the chat. But he deserved to be free. Rico in Atlanta, and he only has 3 months, and the rest of the sentence is suspended. See, that's what I'm talking about. So I think where Jennifer Bonjean is going at is trying to make sure she win New York, because Robert has knocked out 5 years already, and so I wish the best, because I feel like he's been in there long enough. Um, if he was real cautious back then after the trial in 2008, I know he's gonna really be, he's gonna have that PTSD, and he ain't gonna want to deal with. He's not gonna trust people. He's not gonna be trusting these women around him. I guarantee you that bad part is if they kick it back down, he will be in front of the same judge. The judge don't like to correct the mistakes they are. Yeah, I'm telling you, this basically what the judge is trying, the magistrate of appeal is trying to tell Jennifer Bonjean, um, like, you don't know the mind frame, but she's saying, well, every human being has a right to an appeal, and if this man doing this out of retaliation, it's wrong. But the magistrate of appeal is like, well, there's no law on that one. you know do you understand? And she's like, we sat down and we talked about it, and Robert probably told her, let's try it. Let's roll the dice. Let's go ahead and work on this appeal. Everything that Donnelly allowed. Yet, I'm gonna tell you something, Candy. Remember during the trial and stuff, and we was reading that stuff and the hearing and stuff, and I come on and speak and talk about how the judge is saying things. It is so much that can be pointed out in the New York trial, baby. But they only get 10 minutes in New York. They got 15 minutes, though. She gonna have to pick she gonna have to pick the right apples. Jennifer Bonjean, like, okay, this point, that point. She's gonna have to come out and do it in 10 minutes. No, no. Whenever you go for an appeal, you going unless that judge croak before the if they say a retrial. Hopefully, they the one in New York dismiss it, overturn it. You know, but you have to go before the same judge. You have to have the same evidence because they have so many appeals, and so they only give them a certain amount of minutes to do it. So you got to talk fast. You got to know exactly, be prepared for every question the magistrate of appeal asks you. You have to be ready. Okay, you got to be ready. So we're gonna, since it's so short, let me go ahead and finish and let y'all hear what the state is saying.
Mr. Williamson.
This is Mr. Williamson. What the state.
Good morning. May it please the court, Brian Williamson on behalf of the United States. The district court did not procedurally err and did not abuse its discretion with regards to the substantive reasonableness of defendant's 240-month above guidelines sentence. The district court started with defendant's proposed guidelines range and then went above those guidelines range upon a thorough explanation of the 3553A factors. As such, the primary basis for the above guideline sentence was the court's finding that the offense conduct was horrible, horrific, and deserving of very, very serious consequences for Mr. Kelly. I think the court has already picked up on that. Defense counsel loses the forest for the trees a little bit in arguing that the above guideline sentence was based solely and exclusively on the obstructive conduct. And
Is it your view, Mr. Williamson, that the court did rely on the obstruction of justice conduct in imposing sentence?
Your Honor, so I think it's important to clarify that the starting point was adopting defendant's guidelines range. And
but
then,
as a basis to...
Now, okay, obstruction of justice, right? They did, rely on obstruction. That's why they got him, right? They got him for obstruction. And see, and I feel good about that, what Jennifer Bonjean was saying. And then come to find out it wasn't no obstruction. You see what I'm saying? Because the other two was, they didn't obstruct nothing. Wasn't nothing, so he got off that. So that was what they rely on that. So their trial was for obstruction in CP. You see what I'm saying? That obstruction. Just think about it, y'all. So just soak that in for a minute. Let me let them finish talking.
Very.
I think it was a data point in justifying the above guideline sentence. It was not, neither were imposed specifically as a mechanical basis to vary above.
And can you distinguish for me between what you mean by a data point and a basis to vary?
Right, Your Honor.
Did the court consider it? It's hard to tell from the court's comment that it could consider. And I'm not sure there's any specific finding by a preponderance of the evidence as to why the obstruction of justice conduct occurred, or that the government did prove it by a preponderance of the evidence.
Yes, Your Honor. So, the sentencing court found by a preponderance of an evidence that obstructive conduct occurred. Now, whether that comprised a specific part of the above guideline sentence, or whether that was a further justification aligned with the seriousness of the offense conduct, the sentencing transcript does leave that a little bit ambiguous. But it's clear that on the offense conduct alone, the 3553A factors alone, and the seriousness of the conduct, the court could have arrived at the 240-month above guideline sentence by itself. So
just to pin this down with clarity, your position is that Judge Lynam-Weber made the findings necessary to consider the obstructive conduct?
Yes, Your Honor.
Okay.
So as to the obstructive conduct, per this court's precedent, it is not in dispute that a district court may consider acquitted conduct as long as it is proven by a preponderance of the evidence. And that's exactly what the district court did here. Moreover, it's clear what the sentencing court was referring to. He noted a Keystone Cop kind of operation in which these tapes spread throughout the country. And Kelly's minions spent hundreds of thousands of dollars in effort trying to get them back. This is not just about the receipt of the tapes. This is about a broader sense of obstructive conduct. If you read the sentencing transcript in whole, it is quite.
Let me pause on that right there. He said R. Kelly minions spend thousands of dollars to try to get them back, but those minions were found innocent, right? So therefore, that's not relevant what he's speaking on, because they didn't prove that these minions spend thousands of dollars to try to get them back. That wasn't proven. Okay, so at the end of the day, those two were acquitted. So why is he spoken? Because the trial was mostly speaking on obstruction. Remember, they said that Robert won his case, the 2008 trial, because he obstructed justice by paying off, the family to not speak, to leave the country, and getting paying people to get rid of evidence or collect evidence, and that wasn't proven. The obstruction was not proven at all.
Clear that, as the government argued, there was a broader set of obstructive conduct that was in the court's mind when we made those comments. That included conversations that Kelly, the defendant, and his associates had with Jane's parents during the course of the investigation. The result of those comments, including Jane's family's non-participation in the grand jury and subsequent 2008 state trial, payments made to Jane's father during that time period, and others. The burden on the sentencing court to justify an above guideline sentence.
I'm gonna keep pausing because y'all, if I let it go through, I'll forget my train of thought. But they tried to say that the father was paid, but Jennifer Bonjean let them know, oh no, this man worked for Robert. He was playing instruments. He was part of his band, and those payments is to pay this man for work. Okay, so y'all remember that the mother said she went to Robert and asked him to and so the mother of Roshana Landfair went to Robert and asked him for money to open a shoe store. So how can you tell? He can't tell the judge of his findings and his data information that is written in formally legal guidelines. The question, so his data. Yeah, he dodged the question. Back to the bushes. Don't get in the bushes. I want everybody comments last. So this man was being paid. And so if you go back into the Roshana Landfair thing, it showed you that Robert wasn't even dealing with them people like that. And if Robert was keeping them people in control and keeping them on a hush hush, why Roshana Landfair running him down? Then, why did Roshana Landfair have to say, hey, this is my new number. Call mom because my grandmother died. And he said, I'm sorry to hear that. And she was like, she going to him like, oh, we gonna be at the, strip club, and you want to come, invite him. And he's like, I ain't got time for you. So if Robert was worried about Roshana Landfair in the family, and if he was holding these people hostage, he would keep a close eye on them. He would kiss Roshana Landfair ass, which he did not do, and that was proven in court. So if this man was holding these people hostage, keeping Roshonda Landfair from working, she wouldn't have been overseas. And if these people were so afraid of Robert, they wouldn't be going up there trying to ask him for money, right, to do this and that. So Robert didn't have Roshonda Landfair's freaking number or her mother's number. He said, okay, give me her number so I can call her. Now, see, this is what the public doesn't know. But they mad at us because we did our research, because I want to know what the hell was going on. And why the hell this shit ain't sounding right to me. You understand? Because at the end of the day, these people, like I said, Robert was the one, goddamn it, taken advantage of. And you tell me, and the way everybody tried to make this man like all he did was sex. How the hell this man had time to screw people all day, every day, and to make music for himself, #1 hit, and save damn artists' careers, travel, do shows, do interviews, stay in the studios, and keep his damn craft, up to date, and reach out to other artists, to collaborate with them, play basketball. But still, again, who came to who? And ain't no problems. You welcome on here, One Path. I just like I come on y'all panels, like whenever I'm able, if I'm awake or I have energy to watch everybody. I come in and I speak. I don't, we all are grown here. Everybody's entitled to their opinion. Some might like what you say and some don't. There's no problem over here. I want to hear everybody's thought. R. Kelly only guilty of being the damn nice guy and forgiving. Yes. That's it. So I want somebody to explain to me, because I know in sex trafficking, they go in and they snatch these people off the damn streets, and they spend more time working on Robert instead of getting these real peas out there that's going out snatching kids. They spending more resources on Robert that should have been going out trying to find out why all these damn black kids are missing and black adults are missing. Because you know why? A lot of these people are they stealing organs. Have y'all heard of black market organs? The white folks want our organs because they feel like black people are stronger and things like that. You understand? So we know, because we did our research to all the people that had something to say about us. Because remember, I want these people that bash the people that, pouring out the lies from the truth on this Robert Savelli case, R. Kelly case. We know. I experienced a lot of stuff, so I'm speaking on experience. I know about these young girls that run after these older men. I have not seen nobody. There's no evidence of Robert getting anybody, kidnapping them, dragging them in. These women with their phones in this man's house and studio, scared to leave, because it ain't because they scared to leave because they think they're gonna get beat up or killed. No, they're afraid to leave because they scared the next woman gonna get Robert, because they wanted Robert. Why? Because they was chasing his money. Okay, chasing the dream. And then they want to use this man. He is an artist. He used his music to lure women and girls. How the hell a man singing music is luring these women and girls when they need to be teaching these women and girls to be goddamn self-made. But now they handicapping these women by saying, oh, if this man allow you to come to him and do this and say that. No, you better teach them, goddamn it, just keep their legs closed and to be self-made and go get your education and working. So I don't see them going in to all these different other places where they turning down people and they think they the best singers in the world, or actors and actresses in the world, and they say no, and they pick somebody else. I don't see them doing that. If Robert feel like you can't sing, you can't fucking sing. But you say you feel like I'm gonna throw my kitty cat on this man Dang Wayne, and maybe he'll give me a deal. Cause see, he is one of the greatest writers, producers in the world. But see, they teaching these women different. They teaching these women to go after these men, money, using their kitty cat that they was willingly given to them. All I seen was willing participants. I didn't see nobody being forced. I didn't see his damn hand around somebody's freaking neck and forcing them to have sex. I didn't see no minion standing around with no gun while he's forcing somebody. I didn't see that. So you show me. Show me. Y'all gotta show me, because I haven't seen it yet. And I know I've 4 years and a half of research. I haven't seen it. Every woman got up there to run their mouth thinking that they got this going on, going to this media, talking. Them people don't give a damn about them. Go back and see what Gayle King or any of these people did for these so-called victims. Did they send them to college? No, they rely on Robert's money, restitution, and want to get lawsuits to go get boobs and teeth fixed and all this stuff. So if you was in it for the music and you want to sue Robert because he lied about doing a career for you and I want this money, why you ain't get the money to go out to go for your dreams? Only thing they went for was teeth, boobies, damn booty, trips, name brands and the Louis Vuittons and Chanel bags and the buy trips and crap like that. But did you see them do anything to better their lives with the money? Nope. 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 So I don't care what they say, because I want these people that's out here trying to bash the people that know what's going on, that did their research and wasn't listening to the goddamn mainstream media and the Gayle Kings and shit with they live, and they watched the Surviving R. Kelly of live and seen the bullshit for what it was, and the goddamn ex-wife with the 3 kids goddamn lying because she didn't want nobody else to be a part of that. What she do? She jumped in front of the camera and she lied. And I can say you lied. I can honestly say it, and I'm not gonna say alleged, because I go back to your past and I look at the shit. You wasn't scared of Robert. You went to all his damn concerts. You all popping up with your 2 entourage at his birthday party. He didn't pay attention to you. But this man, you scared of him. Huh? Everybody's scared of him, but y'all following him. Then you got these 3 girls going on trips in his van, in his Jeep. You didn't stop by and see. I know you seen state troopers on your trip. I know you seen police stations, fire stations, damn hospitals. You didn't make not one damn stop. You stopped at the goddamn mall. You get your nails done. You went to the places to get your hair done, clothes, all that shit. And I don't care what these people say, because I have 2 boys and 2 girls. I got grandsons and granddaughters. Okay? So they can say, oh, she's a female. Damn it. Accountability over here. Because the person that was on that tape was very experienced. She was doing all the work. Whoever the man was on that videotape wasn't doing it. That female took it very well. Okay? Wrote it very well. Accountability. That's what I look at. Because when my daughter decided she wanted to leave my home where I was taking care of her ass to be with some damn low-life, grown-ass man, and I told her, because see, you know what the police told me? Well, if she leave, we can't force her to come back home. I said, well, I'm finna say this in y'all face to my daughter that I love, that I took care of, and trying to raise her to respect herself and her body. I know that first feeling. That first feeling is something you never experienced in life, and you want it again. Okay? But I said that feeling that you got from that guy, it ain't gonna feel the same. And I said, when you walk in, if you choose him, walk out that door for a good life I'm giving you, and your education, you throw your education away, don't you get mad at me. Oh, she was happy to go there. But you mad at me because I'm telling you, you got to do your part in my house, clean up. But when I go and check on your ass, you got a rag over your head, and you outside with a damn mop and a mop bucket. So you mopping this somebody else's house, but it's killing you to do what you're supposed to do with the roof over your head. So I said, when you walk out that door, I'm going to let life learning lessons teach you. I told her when she walked out, accountability. Accountability. You hear me? So I don't care what these people out here saying, because I know the ropes. I was one of them teenagers that was rebellious, and I ain't want no damn boy. I tell my granddaughter today, slow down, baby. Stay young, baby. Stay a kid, baby. Because, baby, the real world will whip your ass and whip it good. And that's the only thing I can do is give them, the truth. Because, see, if you go back and you look at, those paternity tests, and them old women, they tried to make like they was the best women in the world, but they was out there humping around. And I guarantee you, half of the people do a DNA test with their daddies from them women back in the old days. That wasn't your daddy. And that's what I was seeing a lot of on the freaking deal of this child support cases and DNA cases. You got women in they goddamn 60s and 70s. Then you got women that's deceased, and the girls want to know who their fathers are, and they ain't the daddy, the husband, not the father. But they tried to make it look like they was the best in the world. Okay, look at take for instance, Fannie, right? Fannie Wilson. She portrayed the world as this well-groomed, woman of integrity and things like that. But she bumping and grinding a married man and paying this man all his money. Look at Megan Thee Stallion, allegedly, which I didn't look into, but I heard it from Gary with the T, that she is going with a high schooler, and they talking about congratulations. They like, congratulations. And then you got the media, when they speak on Robert about Roshonda Landfair, they keep saying the 50-some-year-old R. Kelly. No, he wasn't no 50-something. The man was in his 20s back then. But they don't talk about that. After that situation with the court in 2008, that man was very careful. He was very careful. Now, let's look at it. Let's look at what's the damn girl name? The damn Angelo daughter, Azriel Clary. Have anybody read the goddamn text messages from the mama and the daughter? The people that's out here, the media and these damn YouTubers, these bloggers, and understand what went on and how it went on and how the mama lied and covered up, and then her damn ass got scared and said that she was, you better tell him your real age, cause you out there in the public with him now, girl. Everybody seeing you. When she was in here in Houston and they went to Mickey's and all that shit, and everybody seeing her, and she blowing kisses at Robert, and the recording of her up there. And the mama like, damn, you better tell him. No, mama, why you didn't tell him? Because you already know. Azriel was like, I'm in the damn door. You done covered and laughed at me, you and daddy Pappy. So I ain't gonna tell him shit. But after everything started coming in, and the media and the Tim Savages got his ass pissed off because this man didn't do a deal with him and get him a car lot, and then you got the Angelos and shit, and they didn't want to, the Clarys, they didn't get their deal, and Robert said no. So do you think if Robert knew anything and these people had something over his head, you think Robert would have said no? And then Robert didn't give a damn about Roshonda Landfair and her mama and dad and family. Who running after who? Who running after who? I didn't see it. I didn't see this man snatch one heifer. The mamas, the damn daddies, and these girls getting in where they fit in to try to get close to him, using the goddamn bubbles and shit to get into this man's house to set him up. You got a damn attorney putting ads out there, about Robert, and I can get y'all some money. All y'all have to do is take a picture with his ass and prove that you was around him, and I can get you millions of dollars, and I can work through his people because he don't know nothing. He stay at the studio and shit. He got other people working for him. Just like with Don Russell, Robert didn't know Don Russell wanted to do this. Don Russell wanted to protect his shit that him and Robert had going on. He's like, oh, I'm gonna put all this money in and shit, and I got to protect this because this is gonna be big. But Robert was to blame for every freaking thing. Robert was to blame because the mamas and the daddies lied about their daughters' ages. The goddamn Geronda Paces all up in the courtroom when this court's supposed to be 18 and up. She's in there. Robert seen her in there. So you have to be 18. Okay, you got evidence of that. So what the hell going on here? Okay? I don't like it. Because you know what? These police and stuff is messing with my son in this little town. But I got their asses. Because we finna do a part 3 on their asses, them police and them rednecks up there. Because you're not finna be messing with my son. I told them, I said, y'all done mess with the wrong child. Baby. Because if I was this man's mama, baby, I'll be a damn firecracker. So I'm just telling y'all, these people, y'all sitting up there, y'all want to talk all this shit because they found him guilty. They found him guilty by social media, okay? Public persuasion. No people already went up in there with their minds made up. You had immunity for this goddamn rotten ass Demetrius Smith. If the bastard's telling y'all he didn't give a damn about Robert, and y'all try to say that this Robert had these people by the damn neck and they was afraid of Robert, you got this man said he was gonna bash Robert across the head because Robert got more money than him and he need to feed his family and kids, and they stealing motherfucking goddamn credit cards and shit. So if this man was so much of a danger to society, come on now. The man will let you go right? If you're afraid of him, you didn't want to be around him, but you coming back begging him for a job to finish stealing from him. And if you was afraid of him, you ain't gonna steal a damn thing. Right? Robert is a human being just like us. Oh my God, he was screaming and yelling at the female. I would cuss your ass out too. You come and steal my shit. I got a Rolex now in my house, and I can show it to you. And I wish a motherfucker would come in here and take my shit and I find out, because I'm going to cuss your ass the fuck out. Like he don't supposed to confront a motherfucker. He taking care of, giving $10,000 allowances, and the motherfuckers don't even clean up shit. What the hell? We did our research. We did more of research than these damn journalists that's supposed to have been doing their research and facts check to make sure their stories are correct. But what they tried to do was paint a picture of this man and make him look like a monster, just like a Gayle King emotion. He don't have a right to have his to feel the way he feel. He's not a right to have emotions. We all have them. Y'all see how Fanny flipped the damn script and went the hell off? And she was sitting on the damn witness stand. But then nobody called her no fucking monster. You have Fanny saying, stay out of my relationship, my private business, but y'all want to open the door to this man's life, how he screwed. And I still want to see evidence of forced entry of these women. Then you got Portia lying ass, Portia Williams, trying to promote her book. All of a sudden you come out and you hang out with Ashanti McGee lying ass, Lisa Van Allen with her lying ass. Nobody, what a birth certificate. You had Jennifer Bonjean. I need to see birth certificate. And she pointed the lies out. Okay, now what date this was again now, ma'am? Heather Williams. She got up there thinking she finna get big paid, big popping. No, there's a good karma and a bad karma. And these females, because the little feelings was hurt, they did things to try to win a man. You better learn to stop doing that shit. You better stop doing that shit. You running around here using your cootie cop to try to get a man. And that does not happen. These men go get coochie anywhere. But if I go all out and I do this and I do that, I'm a winner. And then when you got this man being honest to you, at least he was honest, because you got a whole bunch of players out there. I was like, these people being mad at me because I'm a player. You wasn't no player, Robert. Players go out and play women. They don't tell them shit. They don't be honest with them. You told them, listen, I'm telling you now, I got 4 chicks in my house. If you want to be a part of our non-J-Twa, you welcome to. If you don't, take your ass on. He didn't tie him up in no damn limo. He didn't tie him up in no house. Talking about they had to go piss in buckets. Maybe a female was in the damn bathroom and did your ass. Now, what's that damn radio station girl, that old one, that left her child and gave all her shit away to go be with Robert? But she mad though. I'm gonna testify against his ass. Yes, you see what I'm saying with karma? Because see, look at Portia. She thought she stole that man from one of them girls that was on the cast of Loving, Atlanta's Housewives. Now this man is a damn fraud. You better watch them people from Africa in a damn way. Better watch them. Better watch them. You better watch them. Now look at this shit. Now she done, Kitty Jones ass. Then you mad, that's retaliation. I'm mad. I'm at the studio. I find out he got 2 women at Trump Towers. I'm staying at a damn studio. That's some damn women that go out and retaliate. All this shit is retaliation, envy, and freaking jealousy. You got Demetria Smith mad because you no longer on the scene. Then you had relatives mad because he had to move on and get better production for his damn, music career. If you ain't experienced, what you mad for? Just support the man. Be there for the man. And learn the business. And then when you learn the business, just like other people, like basketball, it's called practice. You practice so you can win. So you can win, the damn playoffs and shit. And do that. The family. Let me go in and learn this. Let me hang around this man. And yes, what I'm saying, not one of them women, I don't see where no forced entry, no stitches, no nothing. Because if you lying and saying, oh, I was a virgin, this is my first one, and from the size of this man, you should have been at a hospital somewhere. Now, I'm looking at Geronda Page. What, how from 3 to 8? A family member? You ain't called them out. I ain't see a picture of this man that violated you, Geronda Pace Johnson. I ain't see it. All these women, even that damn Me Too woman, the black woman with the big nose, that said when she downstairs she was violated by a friend of the family. Is he in jail? They focus taking their frustration out, just like a bunch of these damn people on the internet. And these people, they got these people that did something to them and they mad as hell, and they took it out on Robert Sylvester Kelly. That's not fair. I'm just gonna be real. I don't give a damn. I'm a loner, and I don't give a damn who don't like what I say. Right is fucking right. And if the man, Robert, if he felt like he did something wrong, y'all done dug all off of his damn thing, and y'all done used a dead person, Leah, and everybody is on their emotions. And oh my God, poor Leah. Y'all saying poor Leah because she died in a plane crash. Ain't no poor Leah because of Robert. Oh, poor Leah. Oh my God. He just messed up her life. Shit, that girl had the best life ever. The short-lived life, but she did her thing. She had a great life. She did a great job with her music career. She went on with her career, and she was with everybody allegedly, having her fun. Having her fun. I wanted y'all to remind me. I'm going to finish letting this play, but I'm finna show y'all something. The Bill Cosby woman. And I'm going to send that to Jennifer Bonjean. I want somebody, and I hope I'm going to have to go in and out and talk because, this is somebody else's stuff, and it's on Netflix. So I'm going to be in and out talking on this one. But this model that tried to get Bill Cosby convicted. She lied and said that her life was all. Hi, Sir Miguel. Lied and she got up there and said that her life had been miserable and she was just up in her own world. And they was talking about the drugs, and this woman got a drug problem. Didn't I tell y'all back in them days? That's all them bastards did. Sniffing and popping pills and shit. I mean, that Bill Cosby didn't have to force no grown ass woman to take no damn pill. She came in there with her own stuff allegedly. From what I'm hearing on here, this woman was she's a hot mess. Y'all hear me? She running around now on this show with her damn whole old wrinkled ass body out, kitty cock showing, breast showing. Getting breast implants and stuff off Bill Cosby money from a lawsuit. You see what I'm saying? They suing these men, but they claiming they ruined my life, but you didn't use the money to try to better your life or do something to upscale your life, but all you want to do is have your old boobies picked up so you can think you looking young, and she looking like a plastic damn goblin from the damn Batman show. Shit. This man ain't perfect. He don't deserve no 30 years in jail behind goddamn willing participants and they damn dusty, no good, rotten ass damn family members. That man didn't go looking for them. Y'all see how them women grabbing him on the stage and trying to pull him and stuff. And from what I see, everybody tried to win for him. Because all I had to do say no. No guns, no nothing. Then you had the damn mama, the first lady and her daughter running around here, and she trying to say he had a gun. This man is a celebrity, okay? A famous artist in a room with somebody he don't know that can do something that Carla B said she used to do back in the day. They gotta have protection. Cause hell, if I was well known and you think I got billions of dollars and we up in somewhere by ourselves, I'm gonna have something to protect myself. Whether I don't care if you're a woman or a man, I don't trust you. Okay, let me finish. Let this play. Let me find this damn bill.
Is not high, and it was more than met here by the court's consideration of the 3553A factors. Moreover, it's also not in dispute that there was no ex post facto violation in the court's reference to the evolution of the sentencing guidelines on sex offenses. Defendant concedes as much in his papers. Your Honor, you mentioned the Coe case, and that's exactly on point here. It actually encourages reference to amendments to the guidelines without reading into the limitations that defense reads into it, that those should be used by later sentencing courts in considering whether their sentences meet what Congress was intending. So at end, the sentencing court based its 240-month above guideline sentence primarily on defendant's horrific offense conduct, not in particular on either his obstruction of justice or the evolution of the guidelines. The sentence was thus procedurally and substantively sound. Turning to the statute of limitations question, defendant's indictment for sexual exploitation and inducement of children was timely brought. The statute of limitations period as to defendant's victims never expired, and at the time of the offense conduct, prosecutions were viable until the victims turned 25. But before Jane, Nia, or Pauline reached the age of 25, Congress in 2003 expanded the statute of limitations period to the life of the child. This was unambiguous. Section 3283 states that no statute of limitations that would otherwise preclude prosecution for an offense involving sexual exploitation of a child shall preclude such prosecution during the life of the child. This is a universal approach to changing the statute of limitations. It's forward-leaning and it's backward-leaning. There is and can be no ex post facto violation when an otherwise viable statute of limitations period, such as we have here, is expanded. Multiple courts of appeal agree on that front. And while this court has yet to have occasion to review that specific question with regards to that specific statute, 18 U.S.C. 3283, it has nonetheless agreed with the principle that no constitutional violation occurs in these circumstances. That's the United States v. Gibson case, relying on Supreme Court precedent in Stagner. The application of 18 U.S.C. 3283 should thus not be considered impermissibly retroactive. It is not reviving a previously moribund limitations period. Instead, it is explicitly precluding the application of prior limitations periods that were anything less than for the life of the child. The indictment
Are
in
you
this case—
saying that the land graph analysis doesn't matter given Gibson?
I wouldn't
Because
set
it seems
aside—
like it's a separate issue. The Gibson is the ex post facto argument, and defendant has conceded that's not what he's pursuing on appeal. Instead, he's arguing the statutory construction, that if you look at Congress's intent, look at the framework under land graph, that Congress's intent was not to make this retroactive, which is a separate issue.
Your Honor, I think the language of the statute speaks unambiguously, and we don't even have to get to what Congress, the underlying intent of Congress was. It's hard to read 3283 in a manner that doesn't apply both backwards and forwards. If we do apply Landgraf, it satisfies both the first step and the second step.
Defendants spent a lot of time in the brief focusing on the Tusi case and the statements that statute of limitations should be liberally interpreted in favor of repose in criminal cases in particular. Can you respond to that argument, please?
Yes, Your Honor, absolutely. So the Tusi case and its progeny, that's a fine statement of what Tusi stands for, but there's always a carve out for when Congress explicitly provides for otherwise. And it's the government's position that that's exactly what 18 U.S.C. 3283 does.
What if we get to step 2 of Landgraf? How would Tusi impact that analysis?
So in a sense, defense is asking for a kind of an exception that doesn't exist with that. Reading repose into the second step of Tusi, in defense's brief, they set out that this creates, there's a broader set of rights and obligations in that than are provided specifically in the second step of Landgraf. I wouldn't say we need to reach the second step of Landgraf because step 1 is satisfied given the unambiguous nature of the statute. And
But if we do,
as to step 2, if there is no retroactivity problem, we're not even in step 2 of Landgraf. And I'm not sure they pointed to a case that says that the repose considerations in Tusi supersede the satisfaction of steps 1 and 2 of Landgraf. So if the court doesn't have any further questions. Thank you.
Thank you.
Ms. Bonjean.
Thank you. Picking up where my colleague left off, our position, of course, is that it is not okay to just jump to the ex post facto problem. And we disagree on how, the language of the statute and what it suggests. We have express language from the bill version that demonstrates a desire to include a retroactivity provision that was then removed. Now, retroactivity doesn't mean an ex post facto violation. And retroactivity could be an ex post facto violation, but it doesn't mean an ex post facto violation. And so we are in this category where we acknowledge that the government, that this was not, again, a situation where the statute of limitations has expired, but it was still retroactive. And there are still considerations that this court considered, and that the United States Supreme Court has said the starting place. And in Landgraf, the court says the default position is prospectivity. So we shouldn't start with the retroactivity unless otherwise. Tusi says criminal statutes should be interpreted in favor of repose. So those general principles, those canons, need to be the starting point. And I think lower courts, to some degree, have gone wayward from that. I think the U.S. Supreme Court might get us back on track with that. And I know some.
But if the language is clear at step 1, that doesn't come into play.
Well, the language,
I understand you don't think it's clear.
Well, I think it's clear in the other direction, but
if it is not clear in the direction you want it to be, then we don't get into the Tusi land.
Well, our position is that the legislative history, we also agree that you don't need to get to step 2. So we're in agreement on that. But, and obviously we would acknowledge that some of these circuits have already sided with the government's position on this, the issues in front of the Second Circuit presently. So
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But perhaps there will be a split at some point. But our position is that the U.S. Supreme Court would see this differently in light of those general principles, and that we need to start there. And I think the court is well equipped with the information that we've provided and the government's provided to make that decision. I want to get back to this obstructive conduct very quickly. I'm still unclear. I think the government is unclear. Everyone is unclear on how the court reached the above guidelines sentence. And I don't think it's sufficient to just say, well, he spent a lot of time talking or speaking about the 3553 factors, and therefore it's all justified. I think that's dangerous, and I think the court needed to be a little more precise with its factual basis. And notably, the government is focusing this court more on a different set of obstructive conduct for which Mr. Kelly was also acquitted, that the district court didn't even mention. The government talks about the intimidating behavior, the hush money towards Jane Doe and her family. And in our reply brief, we honed in and demonstrated for the court that is not what the evidence showed. Jane Doe said nothing of the sort. She said there was no hush money. The mother unequivocally said there was no hush money to testify falsely in front of the grand jury. Nothing of the sort happened. They had their own reasons for wanting to not cooperate with the investigation, and it wasn't as a result of Mr. Kelly's conduct. Now, the government, interestingly, is focusing that court in that direction, but the district court didn't mention it at all. So the district court didn't rely. At no point did the district court say, I'm going to give him an above guidelines range because he engaged in obstructive conduct as it relates to his interactions with Jane Doe 1 or her family. He was more focused on really what was the receipt counts about this wild goose chase. And I want to end on the point that the evidence showed that those tapes that were the subject of the wild goose chase, which were pled and charged in the indictment, did not contain child pornography, contained old-fashioned pornography, if you will. It did not contain child pornography, and the government didn't prove it, which is why the jury came back as it did. And there is really no avenue for the court to find under this lower standard that it did. If it did, then it's unclear why the jury would ever have acquitted any of them on the conspiracy count. So our position is the district court judge got that wrong factually, if he relied on it at all, and that the sentencing justification was too nebulous and that we needed a more precise basis, because how else can Mr. Kelly defend that if he doesn't have a specific articulated basis? With that, I thank your honors.
Thank you. Our thanks to all counsel. The case is taken under advisement.
Okay, moving on. She has to respond to what she can respond to, one pal, because at the end of the day, she's just going by evidence and she's picking out, the good apples. Hey, how you doing? And welcome. I think, okay, let me put on my glasses. Yellow Boy 96, Miss T, London, Renee Jones, to the ones that I haven't speak to. But I feel like she did a good job. Like I was telling them, one pal, like the case law, they speak a whole different language, and it sounds like alien language to us. But like I started like writing down the case laws and looking it up and stuff like that so I could see. But I want to take y'all back to Bill Cosby, one of Bill Cosby's accusers. Y'all remember the model when she was saying she basically just told the judge, it's cool, I'm still prepared to argue my facts at the supreme level. Yeah. Yeah, she just saying, but she was she went in and she was letting them know, because if you remember, do you think this was in his favor? She talked to Robert about it. She gave him the pros and the cons, and Robert, he's a fighter and he'll feel like, hey, I need you to go and do this. And, you're going to tell your client what's best for them, but you working for that client. Jennifer Bonjean is good with her appeals. And let's hope she knocked this one out the box. You have to remember, when you're dealing with CP, it's very, very hard. And if you go back and listen, she brought up the bribery. There was no bribery. He was acquitted for the bribery plus the other two. He was acquitted for that. And this is one of the main things they tried to make it like it was bribery. Like he won that case because he bribed these people. They bringing back an old case, and they say they can bring it back because it was bribery. So just pay attention to what she's doing here. Okay, they opened this whole case over Rashonda Landfair, saying that he bribed her and that's how he won the case. So therefore, we allowed to bring this back, but we're not going to bring it back as child, the CP. We're going to bring it back as bribery. He bribed the witness to not testify. But y'all remember me saying, how was that when all they had to do was subpoena? And she did. She came back with a dope argument response. That's what I'm saying. Jennifer Bonjean, did y'all see? She used every minute. She didn't stutter. She didn't take a deep breath to think. Sister used her time, baby. She put words in every damn minute of the minutes that she had, okay? Minutes and seconds. Seconds and minutes. She put it in there. But I want y'all. Now, how many of y'all remember that model that said that her life is ruined and she was just shy and she was in the shadows and she just couldn't live her life and he ruined her life and I just couldn't go on with my life. We're gonna talk about it. Now, I don't know, but I'll just say this. What I'm gonna play some music in the background. I'm gonna try to keep this live going. But if they end up blocking it, I will have to go in and take this part off so the the appeal argument can stay up there. But honey, I'm finna show y'all this helper. Just give me time to get her ass on the screen. Let me adjust it real quick. Y'all remember her? Y'all remember her, the model? Bill Cosby model? Okay, let me see. Here. Well, put it up for me because honey, I ain't got but put it up for me real quick. I'm gonna play some music in the background.
I am the world's first supermodel.
Now she said Sylvester Stallone paid for them titties, baby. Y'all see that? Sylvester Stallone paid for them titties.
Several outfits that we need for Fashion Week in New York, Fashion Week in Paris. But the thing of it is that I have tricky breasts. When I stand in front of the mirror naked, I always see the ridges.
We have full racks here for you.
I'm gonna have a full rack after I get my boobies done. The red carpet is the red carpet. People critique it. They write about it in fashion magazines. They talk about it on Fashion Police. They talk about it.
Now y'all see that? I wanted y'all to hear that part. Y'all see it? Did y'all hear it? Did she forget what she said? Y'all forget what she said in court on Bill Cosby? She admitting that she's a druggie and an alcoholic. That's why I be saying what I be saying. A bunch of bull crap. Remember that? Now y'all hear her constantly admitting about her drugs. She constantly admitting about her drugs. Ain't that something? Now, you guys, do this look like a woman, that same woman that was talking against Bill Cosby and saying that Bill Cosby did this and that to her? And this was old. This and you can watch it on Netflix. The whole thing. Even they have a reunion. She was out of this world. Oh, I did.